brutality aspect, you see, there were two charges. One was 201, that is destroying of evidence, and the other one was 304, for which my client has been held guilty. So far as brutality aspect is concerned, for destroying of evidence, you can say that was brutality. But so far as charge was concerned, 304 part 1, there was sudden and grave provocation which prompted my client as held by the trial court, which resulted in the death of Neeraj Grover. There is no brutality.
How ridiculously illogical is that?
Ordinary day in and day out, we can see such type of cases where someone under these circumstances loses the control, and the result...
1 minute.
A quick response from
I think this is even more illogical than his opening remarks.
Yes.
He defines destruction of evidence as brutality, not the chopping of the body. A. B. His second point is even more self-defeating. We are not interested in what the charges were. That's exactly my point. The prosecution did not create a case which was comprehensive and complete.
No, we are going by the law. Majid Mehman, quick response. You wanted to come in, and then I'll go to Arun Bhagat, senior police officer. Yes,
Rajdeep,
yes, go ahead.
I would endorse what Suhail is saying, but in a proper legal frame. You see, the benefit of grave and sudden provocation could not have, under any stretch of imagination, be extended to the facts of this case. You see, the man whose prudence gets eclipsed, whose reason gets eclipsed by a particular sight, if he behaves, how does he behave? Even if he shoots somebody and kills somebody, immediately there is a remorse and regret, and then his conduct would be totally different. He would lay down weapon, he would open the door, he would tell the people, neighbors, and go to the police and say, "I'm sorry, I did this," on the spur of moment. That's the person who is entitled to benefit. Not that thereafter, for minutes together, you cut brutally a person's body into 300 pieces and dispose it off. Is this not murder foul? I'm extremely sorry to say that I disagree with the learned trial court by all means.
Okay, you disagree with the learned trial court. Wahab can't respond to that because, you know, in the case of Jerome in particular, your client flies into Mumbai from Kochi, goes straight to Maria Susairaj's house, kills a man, chops his body into pieces, disposes of the body, and you seem to suggest it was just an ordinary crime of passion. Surely this is not an ordinary crime of passion to cut a body into 300 pieces.
You see, if the intention would have been to commit murder from Kochi,
yes,
he would have carried some weapon. If there would have been some conspiracy, then alibi or etc., the 1,000 defense were there, he would have taken those defense. He would have prepared for that. Abruptly, he would not have taken the debit card of his friend and booking the flight ticket at the last 12 hours, 24 hours, the last moment, rushing to Bombay, and then 7:30 directly reaching to the flat which has been purchased or booked by the Maria one day earlier.
Okay.